5 seconds to go. Start. There was an admitted contradiction between the statement given by PW2 before the court and in his section 161 CRPC statement as acknowledged by PW 28. The High Court straightway came to the conclusion that PW 28 was supporting the accused as all of them are the police officers known to each other. Even the occurrence has been spoken differently by PW1 and PW2. The High Court ought not have made reliance upon Exhibit P38 to P41. Exhibit P38 is highly doubtful, however, the same has been improved by Exhibit P41 by introducing the concept of dying declaration after about 40 days, which document came into existence on the insistence of the police, which could be proved through the evidence of PW 25 himself. Thus, when the trial court, which had the advantage of seeing the witnesses in person during their deposition, gave its verdict, it could not have been set aside through a cryptic order by the High Court without adequate discussion. The High Court ought not to have reversed the decision on the basis of a so called dying declaration. The counsel seeks support from his argument by placing reliance upon the following decisions. The learned counsel appearing for the state submitted that the High Court has correctly relied upon the evidence of PWs 1, 2 and 25. PW 25 is an independent witness merely because PW1 and PW2 are the police officers. Their evidence cannot be disbelieved. The High Court also took into consideration the documents marked on the side of the prosecution as relevant materials were indeed taken into consideration. There is no need for interference, particularly when we are dealing with a case of homicide of a police officer. Section 378 CRPC enables the state to prefer an appeal against an order of acquittal. Section 384 CRPC speaks of the powers that can be exercised by the appellate court when the trial court renders its decision by acquitting the accused. Presumption of innocence gathers strength before the appellate court. As a consequence, the onus on the prosecution becomes more burdensome as there is a double presumption of innocence. Certainly, the court of first instance has its own advantages in delivering its verdict, which is to see the witnesses in person while they depose. The appellate court is expected to involve itself in a deeper studied scrutiny of not only the evidence before it, but is duty bound to satisfy itself whether the decision of the trial court is both possible and plausible view. When two views are possible, the one taken by the trial court in a case of acquittal is to be followed on the touchstone of liberty, along with the advantage of having seen the witnesses. Article 21 of the Constitution of India also aids the accused after acquittal in a certain way, though not absolute. Suffice it is to state that the appellate court shall remind itself of the role required to play while dealing with a case of an acquittal. Stop.